Hello, this is Dr. Barney, and during this brief session, we are going to be introducing ourselves to the human rights documents that have been produced by the United Nations. Now, it's important to note that the United Nations is not the only international organization to have developed human rights documents. There are a number of other human rights documents that have been developed by international groups, such as the European Union. There's also an American Convention on Human Rights that have been developed by Latin American nations. And really, the list of organizations that have developed these human rights documents go on and on. However, given the scope and the reach of the United Nations and its importance in the international arena, we are going to be focusing specifically on exploring the human rights documents developed by this particular organization. Now, the United Nations has developed a number of different types of human rights documents. Probably the one that most of us are familiar with are declarations. And a great example of a declaration is the Universal Declaration of Human Rights. Most people are familiar with this because it was written originally for the layperson so that anybody could understand it and apply it. It wasn't just for those with legal expertise or with academic expertise. But it's for everyone. However, what most people are not familiar with is that this actually represents a non-binding statement of intent to recognize and uphold human rights by individual nations. Now, when I use the term non-binding, what this means is that it is not legally binding. Countries are not legally bound to uphold the Universal Declaration of Human Rights. Instead, it functions more as a mission statement. It emphasizes a number of important human rights, such as human dignity, non-discrimination, civil and political rights, economic, social, and cultural rights, as well as solidarity rights. It is still important even though it's non-binding because this was actually developed at the onset of the United Nations back at the end of World War II. So this was a document that received a lot of attention and it allowed for individual nations to come together, voice their opinions and their intents very early on when the United Nations was started. Now, another important type of human rights document is a covenant. A covenant is considered a binding promise between two or more countries to enforce specific laws. Now, in order for a covenant to come into effect, a specified number of countries must sign a covenant. Countries that sign a covenant indicate that they intend to bind themselves to the provisions within the document. However, just signing the document isn't enough. The document then must be ratified by each nation's legislature. So, for example, in the United States, if we wanted to ratify a human rights document that we have signed ourselves to, it must be signed by the president as well as have a 2/3 Senate vote. Okay, so this is something that has to be ratified by individual nations' legislatures. Now, as I'd spoken about covenants on the previous slide, what I'd mentioned was that there are signatures that have to take place, and these documents also have to be ratified. I'm just going to explain what these terms mean in a little bit more detail. A signature really is the preliminary endorsement of the instrument itself. Signing does not create a binding legal obligation, but what it does is it indicates that countries are going to pursue legal ratification. They're going to be taking it to their legislature in order to have it ratified. So that's what the signature means. Ratification, however, is the act by which a nation signifies the agreement and legally binds itself to the treaty. Basically what they do is they take that treaty and they make it part of their national law. A third term that we haven't yet discussed is accession. And this is the act by which a state signifies its agreement to be legally bound by the terms of a particular treaty, and it has the same legal effect as ratification, but it is not preceded by an act of signature. So accession is when a nation ratifies the treaty but never actually did sign that particular treaty. Now, a great example of a human rights covenant that was produced by the United Nations is the International Covenant on Civil and Political Rights. This really is the teeth of the Universal Declaration. It's a completely separate document, but this is the legally binding version of civil and political rights that were originally identified in the Universal Declaration of Human Rights. Some examples of human rights that are addressed in this particular document include prohibitions against discrimination, against torture, against slavery, and limitations on the death penalty. These are all important issues that are discussed and highlighted in the International Covenant on Civil and Political Rights. Now, most nations across the globe have ratified the International Covenant on Civil and Political Rights. This means that they've actually taken this document to their home nations' legislatures and have had it passed and ratified through laws in their home countries. You'll see a few exceptions have been made. You'll see in Far East Asia, China is one of the state parties that have signed the document, but that has never really ratified this particular document. So it's not legally binding for China at this point. Now, this being said, there are some nations, like the United States, that have ratified these covenants but have given certain caveats. They've made reservations or understandings and clarifications about the extent to which they will actually ratify this document in their national legislature. In the United States, for the Covenant on Civil and Political Rights, the United States has indicated that no further action is needed for free speech. They're not going to do anything to increase this because it's already a part of the Bill of Rights. It reserves the right to execute persons under the age of 18, so they have exempted themselves from that particular human right. They've also said that cruel, inhuman, or degrading treatment or punishment will only be enforced based upon the United States Constitution. And they've also stated that the articles in this document are not self-executing. This means that the covenant on its own isn't enough. There has to be legislature and enforcement through the courts and other legislative means. Now, another important covenant, human rights covenant, is the International Covenant on Economic, Social, and Cultural Rights. This one came out at the same time as the Covenant on Civil and Political Rights, but it had a very different emphasis. Again, it's more on economics, it's more on cultural rights and these types of things. So examples of some of the human rights addressed in this document include the right to work, the right to safe and healthy working conditions, the right to form trade unions, the right of everyone to have Social Security, and the widest possible protections and assistance within that nation. So again, a very different focus in this covenant, but still one that's seen as being very important. And what you'll notice here is that a number of states, a large number of states, have ratified this particular treaty in the international community. This means, again, that they have signed this into law in their home countries. However, the one that really stands out is the United States. It originally signed this particular covenant, but never did ratify it in terms of legislation in its home country. And the reason for this is because you have to consider in the United States, we really do place a lot of emphasis on civil and political rights, but in terms of economic rights, this is a topic that is much more widely debated. So things like Social Security, welfare, health related policy, and these types of things is much more hotly debated and has not been successfully passed in our own legislature. Now, in addition to declarations and covenants, there are a number of other different types of documents and human rights instruments that have been written by the United Nations. And really they can be divided up into these two major categories, non-binding and binding. So anytime you read of documents or human rights documents that are declarations, principles, guidelines, standard rules, or recommendations, we know that these are non-binding instruments. They are not legally binding. However, covenants, statutes, protocols, and conventions, these are the legally binding human rights instruments. And there's a long list of these. There's actually over 80 human rights instruments that are out there that were developed by the United Nations. Now, in terms of how these human rights are actually monitored, countries are actually expected to provide progress reports for the treaties that they have signed, and these are monitored and reviewed by treaty monitoring bodies. So this is an ongoing process, something that is continually happening. One of the big questions that many people would have, especially social workers, is how could we actually help in terms of monitoring human rights and ensuring that people's human rights are protected? Well, one of the big ways in which this is done is through criminal suits. Criminal suits are often brought against perpetrators using laws within individual nations, and this is very effective when a country has ratified a human rights treaty or a human rights document. This isn't always possible, though. Sometimes there are nations that have not ratified these documents, and then in other cases, there's going to be corruption that occurs within nations that prohibit people from being prosecuted for violating others' human rights. In these types of cases, it's rare, but what sometimes will happen is that special tribunals can be established where criminal trials have not been possible at a national level. And some good examples of this include the International Criminal Tribunal for Rwanda, and there was also one for Yugoslavia that was developed. So the United Nations sometimes will put together tribunals to prosecute perpetrators or those people who have violated human rights on a massive or a large scale. Now, another thing that social workers can do to help is that they can work as advocates and help provide information for monitoring bodies that are constantly reviewing and keeping an eye on human rights violations in the international community. They can write directly to the United Nations to appeal for help, and this is how oftentimes a number of human rights violations will come to the attention of the United Nations when individual agencies, nonprofits, non-government organizations, journalists, and even individuals within a nation appeal to the United Nations for help. And then finally, another thing that social workers and others can do in order to help monitor and uphold human rights is to persuade their own home nations. And this is really macro level advocacy because individuals can have power when they collaborate with others to help oppose and address human rights violations, but nations can be even more effective because of the clout that they hold, the persuasiveness that they hold in the international community. So sometimes just by appealing to your own home government, such as the United States government, the U.S. government can actually help persuade and enforce human rights on an international level. One important issue that we should address when talking about human rights documents has to do with how they're interpreted. And this is where we turn to a discussion of universalism versus relativism. According to a universalist perspective, human rights should be universally valid and true principles, independent of any sort of social, political, economic, historical, religious, intellectual, or cultural considerations and conditions. Now, a great example of this is a quote that states, "The World Conference on Human Rights reaffirms the solemn commitment of all states to confirm their obligations to promote universal respect for and observance and protection of all human rights and fundamental freedoms for all in accordance with the Charter of the United Nations." So again, this sees these rights as being true independent of any sort of cultural interpretation of those rights. Sometimes this is referred to as strong universalism, and it's based upon the claim that there exist a limited number of moral ideals that are universally valid, even though these values have not been recognized as valid by everyone in every place. So they're universal even when there are a few people who might object to them. There are some criticisms, though, of this particular perspective. One of the big ones is, how can we mandate human rights when we can't even agree on some of them ourselves? Take, for example, our earlier discussion of the Covenant on Social, Cultural, and Economic Rights. This is a particular treaty that the United States has not ratified because we have so much conflict within our own nation about issues of economic justice. So if we can't agree on economic justice within our own nation, how could we ever expect to apply these types of principles to all places and all times and make them universally true. This doesn't just extend to discussions relating to economic justice or the economic covenant. Really, this also applies to the Covenant on Civil and Political Rights. In that particular document, it talks about prohibitions against torture and the death penalty, but these are issues that are hotly contested within the United States. So again, if we can't agree on them, how could we consider them to be universally true or universally valid? One of the other big criticisms of this particular approach, of the universal approach to human rights, is that universal rights are often just an excuse to promote cultural imperialism, where one nation imposes its ideas and its values on foreign nationals. This is often motivated by ethnocentrism, which says that our culture or one culture is going to be greater than another. So it prioritizes the values of one culture over another. So it's a big shortcoming of approaching human rights from a universalistic standpoint. On the other end of the spectrum, there's what's known as relativism. And a great point about how how relativism applies to human rights states that moral relativism often takes the form of a denial that any single moral code has universal validity, and an assertion that moral truth and justifiability, if there are such things, are in some way relative to factors that are culturally and historically contingent. So this particular perspective emphasizes the cultural origins of moral beliefs, these ethical codes and the human rights that we've developed. It emphasizes cultural and moral diversity. It emphasizes how human rights are going to be different within different cultures. And as a result of this, human rights are going to be developed differently. They're going to look different in each of these different places. However, cultural relativism also has its own set of criticisms. This particular approach is not free from blame. The problem is that a value may be in accordance to the internal standards of a culture, but sometimes it's going to contradict the external universal standards that have been agreed upon by the global community. So this is one big criticism. Now, one of the other issues is that sometimes things that are perceived as being very negative in the global community are going to be perceived by individual cultures as being more acceptable. Take, for instance, something like cannibalism or headhunting. If we were to follow the idea of, or the approach of cultural relativism in a very strict sense, we may have to say that cannibalism is going to be okay because some cultures allow for it. Some have even argued that if we took it a step further, cultural relativism would have not provided justification to fight the Nazis in a domestic way. As soon as they entered the international arena and started impeding upon other nations, then we might have had some ground to stand on. However, if they had just confined themselves to Germany and the Holocaust within Germany and all the different types of human rights violations that occurred, we may have said, well, cultural relativism allows for those types of crimes to occur. So both universalism as well as relativism, both those approaches have a number of downsides to them. They have a number of criticisms. A third alternative has resulted, or has been developed as a result of the shortcomings of each of these approaches. This particular approach is known as weak universalism, although sometimes it's referred to as soft relativism. And it recognizes that there are no easy answers to human rights. It recognizes that human rights are based upon a number of cultural and religious elements. And a great quote to help exemplify this particular perspective of human rights states that international human rights institutions have generally accepted that universal human rights standards ought to be interpreted differently in different cultural contexts. So it recognizes the universal nature of human rights and yet also emphasizes cultural relativity and how they are approached and how they play out in individual nations. It also simultaneously calls attention to suffering and injustice, yet questions simplistic and imposing moralization that fails to recognize diverse and different options. This really emphasizes the importance of context. So instead of just saying that women's rights should be upheld, it recognizes that women's rights should be upheld. However, in many cases, women's rights in the West are going to look very different from the way they look in other nations and in other cultures, because we focus very heavily on individualism in places like the United States and in Europe, whereas in other places it may be more of a group-based approach to upholding women's rights. So they're going to look a little bit different in different places. Some have suggested, based upon this perspective, that international human rights law should really be minimal and should allow more cultural groups to determine the specifics of how human rights are going to be upheld and play out within their own societies. Now, there are a couple of different embodiments of soft relativism or weak universalism. Ramon Penekar was an Indian theologian and a priest who actually developed an idea known as homeomorphic equivalents, and this really coincides with soft relativism. And it says that if we examine non-Western cultures, it doesn't make sense to ask whether that culture also has a concept of human rights. We need to look instead for functional equivalents or homeomorphic equivalents, concepts that serve the same societal function. So in the West, we may have developed human rights, but another culture may approach it a little bit differently. They may emphasize cultural values such as karma, and those types of concepts might be used to have the same functional equivalent or functional purpose as human rights does. So according to this particular approach, human rights shouldn't be pursued, but instead the values behind those human rights should be approached and should be flexible across different cultural groups. Another embodiment of soft relativism is known as pragmatic solidarism. What this really focuses on is the practical or useful nature of culture. And how value should be created within particular communities. It really argues that value should be developed and identified democratically within each individual society. And each individual within that society should be allowed to voice concerns and identify the values that they would like to adhere to, making sure that potentially marginalized or previously oppressed groups should be allowed to participate in that process so that they will not have their rights excluded. So really the emphasis of pragmatic solidarism is to take what happens on an international level at the United Nations and allow this to occur individually in each cultural and community context so that individual groups can have their own rights identified and developed.